Let's jump right in. Today on The Explainer, we're diving deep, like foundational level deep, into the true architecture of cyberspace and the law. We're going to unpack how highly abstract internet philosophies from the 1990s didn't just fade away in old academic journals. They actually built the very real structural foundations of Indian cyber law that govern over 1 billion people today. We have a lot of ground to cover, and we are absolutely going to explain everything in depth, from the global theoretical bedrock right down to the massive modern criminal law overhaul.
Okay, let's dive into this roadmap. First, we'll hit the great cyberspace debate. Then, trace India's legal cyber framework. Unpack the 2023 criminal law overhaul, analyze the Shreya Singhal free speech case, and wrap up with a pretty shocking enforcement reality check.
Starting off with Section 1, the Great Cyberspace Debate. This is the bedrock of the 1990s internet.
Now, the contrast between the early visions for the internet is just incredibly stark. Picture 1996. John Perry Barlow releases his famous declaration of the independence of cyberspace. He championed what's known as cyber exceptionalism. Essentially, he argued the internet was this genuinely new, totally borderless space, and because online actions routine sever the link between a physical location and its effects, Barlow firmly believed territorial governments had absolutely no legitimate authority there. But then, fast forward just 2 years to 1998, and Jack Goldsmith pushes back hard with the regulability argument. Goldsmith said, well, actually, physical states retain every single tool they need to control the web. How? By simply regulating the local hardware, the intermediaries, and the internet service providers physically sitting within their borders, completely regardless of where the data originally came from.
And that entire debate got turned on its head in 1999 by a scholar named Lawrence Lessig. He dropped this incredibly famous realization: code is law. This wasn't just a catchy tech slogan, you know? It was a profound insight that software architecture itself acts as a massive, powerful regulator. Think about it. A platform's technical design doesn't just make certain conduct illegal, it can make it literally impossible to do in the first place. The software code does all the heavy lifting that traditional paper-based statutes just can't pull off.
Lessig expanded on this idea by identifying 4 distinct forces that constantly constrain our behavior online. You've got traditional law, social norms, the market, and architecture, which is the code itself. So why does all this 90s theory actually matter to us today? Because India's entire regulatory approach planted its flag squarely in the Goldsmith and Lessig camp. When we look at India's laws, they aren't generally trying to exert some direct extraterritorial control over the entire global internet. Instead, they focus intensely on regulating domestic intermediaries and the physical infrastructure right there in the country.
Let's move to Section 2, India's legal cyber framework, and see how this actually works in practice.
Let's move to and see how this builds into a really rigid, structured hierarchy. At the absolute foundation, you have the constitutional bedrock, specifically Articles 19(1)(a) and 21, which protect free speech and privacy. Every single piece of cyber law has to survive scrutiny against these fundamental rights. Sitting just above that is primary legislation, which is spearheaded by the Information Technology Act of 2000. And then finally, capping it off at the top level, we have subordinate or sector-specific legislation. We're talking things like the IT rules and the new 2023 Digital Personal Data Protection Act. These basically fill in all the complex operational details that Parliament leaves to the executive branch to figure out.
Zooming in on that primary legislation for a second, the IT Act of 2000 was pushed through incredibly rapidly. It was explicitly modeled on the 1996 UN Model Law for Electronic Commerce. Now here's an important detail. India is a dualist state. That means international model laws don't just automatically become the law of the land. Parliament actually has to explicitly legislate them into domestic law, and they did. The bill was introduced in December 1999, and by June 2000 it already had presidential assent. That speed made India roughly the 12th country in the entire world to have dedicated cyber legislation. Pretty impressive.
By pulling that UN model into reality, the IT Act locked in 2 absolutely massive core doctrines. First up is functional equivalence. This just means an electronic record perfectly satisfies any legal requirement for something to be in writing, as long as it can be accessed later. Second is non-discrimination. This means you can't say information is legally invalid just because it's in a digital format. These 2 concepts were game changers. They gave electronic commerce the legal footing it desperately needed, and they simultaneously forced massive offline laws, like the Penal Code and the Evidence Act, to wake up and recognize this new digital reality.
Which brings us nicely to Section 3, the 2023 Criminal Law Overhaul.
Look, the legal landscape obviously didn't freeze in the year 2000. We actually need to pivot right now to a massive structural earthquake that just took effect on July 1, 2024. India's entire general criminal law framework was completely overhauled. Those colonial-era laws from the 1800s, they're gone. The Indian Penal Code is out, replaced by the Bharatiya Nyaya Sanhita. The CRPC is now the Bharatiya Nagarik Suraksha Sanhita, and the 1872 Evidence Act, replaced by the Bharatiya Saksha Adhiniyam. All of these got presidential assent on Christmas Day 2023. This is absolutely not peripheral trivia. Going forward, any understanding of cyber law has to sit squarely on top of these three new acts.
And if there is literally one single number you take away from this entire criminal law overhaul when it comes to cyberspace, make it this one: 61. Specifically, Section 61 of the New Evidence Act, the BSA.
So the crucial point is this. Section 61 now treats electronic and digital records as primary evidence. That means they are on completely equal footing with a traditional paper document. This is a monumental shift. Under the old system, the old Section 65B regime, electronic records were treated as a secondary category. You had to go through this whole separate, cumbersome certification process just to get them admitted in court. That old framework is officially dead. Digital isn't the backup anymore, it's the main event.
Moving into Section 4, Shreya Singhal, free speech. Let's see what happens when theory actually hits the courtroom.
So back in November 2012, this was absolutely not a theoretical question. Two young women in Mumbai, Shaheen Dada and Renu Srinivasan, were physically arrested by police. Their crime? Shaheen wrote a Facebook post questioning a citywide shutdown after a political leader died. And Renu? She simply liked the post. That's it. They were arrested under the IT Act. You might be wondering, how on earth was that even legally possible?
Well, the police used Section 66A of the IT Act. Now, interestingly, this section wasn't even in that original year 2000 Act we talked about earlier. It was quietly slipped in during a 2008 amendment. It criminalized sending information via computer that was grossly offensive, menacing, or caused annoyance or inconvenience. I mean, talk about vague language. What exactly counts as annoying? Following these arrests, a law student named Shreya Singhal filed a famous public interest litigation, directly challenging the constitutionality of this incredibly broad law.
The Supreme Court takes the case, and on March 24, 2015, a two-judge bench delivers an absolute bombshell of a ruling. They struck down Section 66A entirely. They declared it unconstitutional and void ab initio, which is a powerful legal concept, basically meaning the law is treated like it never even existed in the first place. The court ruled that terms like grossly offensive and annoyance were just impermissibly vague. They gave law enforcement no clear standards whatsoever, which created a massive, unconstitutional chilling effect on legitimate free speech under Article 19(1)A.
And this brilliantly illustrates how the court balanced the entire digital ecosystem. While they completely nuked Section 66A, they also looked at Section 79, the intermediary safe harbor provision, and read it down. They clarified that platforms like social media companies only have to take down content if they get an official court order or a government notification, not just because some random private citizen complains. Plus, they upheld Section 69A, saying yes, the government does actually have the constitutional power to block content, provided they follow specific procedures. Ultimately, this foundational case proved definitively that online expression in India gets the exact same constitutional scrutiny and protection as offline speech, period.
Finally, Section 5, the enforcement reality check. Because, unfortunately, the story doesn't just end with a neat Supreme Court victory.
Let's look at this timeline. The initial arrests happened in 2012, and the Supreme Court totally struck the law down in 2015. But jump ahead to October 2022. For 7 whole years after Section 66A was declared unconstitutional, police stations across the country just kept filing FIRs and charge sheets under this dead law. It literally required an emergency intervention by Chief Justice U.U. Lalit in 2022. He had to order all high courts and police departments to circulate the 2015 judgment and immediately drop every single pending 66A prosecution.
What this reveals is a truly shocking gap between the highest court in the land and the local police station. Thanks to sheer institutional inertia and just incredibly poor dissemination of the original ruling, a completely unconstitutional law continued to ruin people's lives for nearly a decade. It turned the Shreya Singhal case from what seemed like a pure free speech victory into this sobering case study on the intense, real-world struggle of judicial executive follow-through. Which leaves us with this final, pretty provocative thought.
We started out today with these grand theories of cyberspace exceptionalism and the intricate structure of India's statutes. We saw the Constitution fiercely protect digital speech, but you have to ask, does a landmark constitutional victory truly matter if the folks on the ground fail to implement it? The tension between the code of the law and its actual, messy, real-world execution, that's the true frontier of cyber law today. Thank you so much for joining me on this explainer. Keep asking the hard questions, and I'll see you next time as we continue to decode the systems running our world.